Let's go ahead and get started on cause number 1811759, Robles versus Billy Mizell, 5J Oilfield Services LLC, M50 Heavy Haul LLC, Christine Martz and Thomas Stanford. We're having a default judgment hearing involving the defendant, Thomas Stanford. Counsel, make your appearances.
Yes, Your Honor. My name is Brian Arnold, and I represent the plaintiff, Raul Robles. And we are here today for a default prove-up on the remaining defendant, Thomas Stanford Jr. The other parties have already settled. And although Mr. Stanford was duly served with citation and quite some time ago, citation has been on file. He was served a citation more than 20 days ago, and the citation has been on file with the court for at least 10 days. We've also filed a last known address, certificate of last known address, and a non-military affidavit. And in addition to that, we also filed an affidavit, which was signed by Mr. Robles with attachments. So I'd like to go ahead and proceed with the prove up.
Okay.
Okay. Mr. Robles, are you there?
Yes, sir.
Okay. Can you please state your full name for the record?
Raul Robles.
Okay. And you currently reside in Dallas County, Texas?
Sorry, was he sworn, Judge?
He was not. Please raise your right hand, Mr. Robles. You swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Yes.
Okay.
Okay.
Go ahead,
Sorry
Mr.
about
Arnold.
that. Okay, and you currently reside in Dallas County, Texas,
Yes.
and you are the plaintiff in this matter?
Yes.
Now, previously, before this hearing, you signed a sworn affidavit, which we filed with the court. Do you remember that?
Yes.
And so your affidavit is basically a summary of your testimony here today. Is that correct?
That's correct.
So on or about September 18, 2016, you were involved in an accident on I-20 in Grand Prairie, Texas. Is that correct?
Yes.
And in fact, it was a multi-car collision, correct?
Yes.
And one of those cars involved was driven by Mr. Thomas Stanford, one of the defendants. Is that correct?
Yes.
And it's my understanding that you were driving in an awful manner on the freeway when you were struck by a tractor trailer truck. Is that correct?
Yes.
And the impact pushed your car into another car. Is that correct?
Yes.
And you were injured in this collision?
Yes.
Now, it's my understanding that Mr. Thomas Stanford, the defendant that we're here for today, was following too close to another car and rear-ended it. Is that correct?
Yes.
And in fact, you were struck by a truck that was trying to avoid that collision. Is that correct?
Yes.
Okay, so the defendant, Thomas Stanford, was the cause of the collision that resulted in your injuries that brought you here today. Is that correct?
Yes.
And you stated that you suffered personal injuries and because of this accident, correct?
Yes.
Now, the medical records show that you injured your neck, your back, your shoulder, and your body generally, but most seriously your back. Is that correct?
That's correct.
Were these injuries painful to you?
Yes.
And are you still suffering from these injuries?
Yes.
Did you seek medical treatment for your injuries?
Yes.
And in fact, you saw several doctors for your treatment. Is that correct?
Yes.
And you were treated with physical therapy and also facet injections into your back. Is that correct?
That's correct.
Were these painful?
Yes.
And is one of your doctors recommending that you undergo surgery to your back?
Yes.
Okay. And Did he give you an estimate as to how much it's gonna cost?
Yes,
Okay, and that's attached to your affidavit that you filed with the court, isn't that correct?
yes,
Okay. And are you still suffering pain and stiffness for your injuries, from your injuries today?
yes.
And is it hard for, let me strike that. Can you do the things that you used to do prior to this accident? Can you do those things now?
No,
Okay. Is it hard for you to sit for long periods of time or stand, bend or stoop? Is that
yes,
correct?
yes,
And did you incur medical expenses for the treatment that you received up until today?
yes.
And it's my understanding that those expenses are over $20,000. Is that correct?
That's correct.
Okay. Do you believe that you should be compensated for this expense?
Yes,
Okay. And again, your surgeon, Dr. Hotham, discussed with you how much your surgery will cost, didn't he?
yes,
Okay. And that estimate's attached to your affidavit, as we stated, and it's the estimate's approximately $268,000. Isn't that correct?
the, that's correct.
Okay. And were you employed at the time of the accident?
Yes,
And who were you employed by?
that was restoration,
And what did you do for them?
D-flow tech.
Okay. And so have you been able to work since the collision?
I'm sorry, this is the reporter. I didn't understand that answer. What did you do for them?
Oh, he stated he was a deflood technician.
Yes,
Thank
They
you.
go in and clean up flooded places and stuff like that. So as a result of this collision, Mr. Robles, have you been able to return to work?
no,
And is that because of the disability that you have to your back and neck?
yes,
In fact, you're waiting to undergo surgery to hopefully correct that. Is that correct?
that's correct.
Now, how much do you make when you work for Dalworth Restoration?
I was making $15 an hour plus time and a half on overtime.
So it's my understanding that you got at least 15 hours of overtime per week. Is that correct?
That's correct.
So at 40 hours a week plus 15 hours of time and a half, if you add that all up, you had an annual income of approximately $48,750. Is that correct?
That's correct.
Okay. So if you put pencil to the paper and did the math, you'd have an average weekly wage of approximately $937.50. Does that sound right?
Sounds correct.
Okay. So because you haven't been able to return to work due to your accident, to date, you've sustained approximately $190,312.50 in lost wages. Is that correct?
That's correct.
And that would be, we got that figure, you and I got that figure by sitting down and multiplying your average weekly wage of $937.50 times 203 weeks that you've been off. Is that correct?
That's correct.
Did your doctors tell you, did Dr. Holtham tell you that you'd be able to return to work with Dalworth doing what you did before the accident?
Yes,
He told you you wouldn't be able to, isn't that correct?
that's correct.
Okay. How old are you now, Mr. Robles?
52.
Okay, pretty young. So did you intend to work until you retired?
Yes,
And we talked about that and we figured that you expected to work at least 14 or 15 years more, isn't that correct?
that's correct.
And now you're unable to do that job and make that income because of this accident and your injuries, is that correct?
That's correct.
So you've lost those future wages, correct?
Yes,
Now, do you worry about your injuries and the results of surgery? Do you worry about that?
Yes,
Do you lose sleep over it?
yes,
So, as a summary, your affidavit stated what damages we believe that you suffered. So basically, just let's go over that real quickly so we can finish up here. You've incurred approximately $20,000 in medical expenses. Is that correct?
that's correct.
And Dr. Holtham told you about, discussed with you surgery, and then after surgery, some of your expenses that you would incur. Do you remember that?
Yes,
And on top of his surgery, he thinks you incur other expenses for physical therapy and so on. So he believes you'll incur approximately $300,000 in future medical expenses. Do you remember him discussing that with you?
yes,
Okay. And you believe you've incurred approximately $25,000 in out-of-pocket expenses?
yes,
Okay. And we talked about your past lost earnings, but for future lost earnings, we believe that you will incur approximately $682,500 for future lost earnings. Does that sound correct to you?
sounds correct.
And you're asking the court to award you for $150,000 for pain and suffering and mental anguish
Yes,
in the past.
yes,
Is that correct? And you're also asking for $150,000 for future pain and suffering and mental anguish. Does that sound correct?
sounds correct.
Did you incur these damages as a result of the defendant's negligence?
Yes,
Okay. And are you asking the court to enter a judgment today on your behalf?
yes,
So adding up all the numbers that we set forth in your affidavit as a summary, are you asking the court to award you $1,506,562 to compensate you for your past, present, future pain and suffering, mental anguish, physical impairment, medical expenses, and lost wages?
yes,
Okay. One last question here, and we went over this too. In regard to the costs that you've incurred to bring this lawsuit, my records show that you've incurred approximately $909.25 for filing fees and what we call taxable court costs. Is that correct? Remember we talked about that?
yes,
Okay. And are you asking the court to award you the costs that you incurred to bring this lawsuit too?
yes.
Okay. I pass the witness, Your Honor.
All right, call your next witness.
I have no other witnesses, Your Honor.
And you submitted all of the medical records affidavits already here.
I believe most of the affidavits have been submitted, and also Dr. Holtham's estimate was submitted as an exhibit to Mr. Robles' affidavit.
All right, I'll take judicial notice of the file, award a default judgment as requested. So good luck, Mr. Arnold. Good to see you, and be safe out there. Mr. Robles, nice to meet you. I hope you're safe out there.
Nice to meet you too.
Thank you, Your Honor.
All right,
Be safe too.
We'll go ahead and
Thank
get this scanned in today.
Okay, thank you.
All right, bye-bye.
We excused?
You are excused.
Thank you, sir.
Okay. We have Robles. Do we have anyone else here? Let me stop sharing. I'll go. Is there any attorney? Mr. Hopkins, what are you here for? And Mr. Kasib?
Got a motion for protective order, Your Honor.
Let me pull that up. So is that, which case is that in? Is that in the Casey case?
Yes, Your Honor.
All right, let's, we'll go ahead. Are you guys both here and ready for that?
Yes, sir.
Yes, Your Honor.
Okay, we're still live on YouTube. Let's go ahead and go on the record on cause number 205798. Council, make your appearances.
Jason Hopkins, DLA Piper, on behalf of the plaintiff.
David Kasab on behalf of Amir Skandari.
Let's go ahead and proceed.
Thank you, Your Honor. I asked the court for 10 minutes on this motion, and I intend to stick to that. Court will recall we were in here on July the 10th on a motion for summary judgment on the claim at issue. That motion remains pending. Should the court grant that motion, this issue would be moot because this is discovery into the claim we were moving on. This case began, Your Honor, with an attempt by Mr. Skandari to harm Casey's business. That was, the court may recall, the filing of a lawsuit in Houston that included all sorts of gratuitous statements about Casey. The lawsuit was against Skandari's former lawyer. Casey's not a party to it, has no interest in the outcome, but there are all manner of gratuitous statements in there that impugn Casey. The problem with that is we have a prior settlement agreement that says, don't say disparaging things about the settling party. So we brought this lawsuit to enforce that settlement agreement. We're asking for two things: a declaration that the lawsuit that Mr. Kasab filed in Houston constitutes a breach of the settlement agreement, and an injunction of similar breaches on a go-forward basis. Mr. Kasab served the discovery we're here on right now, and I asked him what the basis for all of this discovery was, and he said, well, it was a loss of reputation theory. He's consistently characterized this as a defamation case. It's not. There is no loss of reputation damage model being sought. In fact, there are no damages at all being sought. Again, this is a straightforward declaratory judgment and injunction case. The only question that any of this discovery could possibly be relevant to is whether there is a, quote, threat of reputational harm supporting an injunction. And that threat language comes from the Premier Pools case, Dallas 2016, that we cited in our motion for summary judgment. So all of these discovery requests go to that issue. I want to provide the court with a sample of some of the requests that Mr. Kasab says go to that. On request for production, these are at page 37 of our motion. He asked for true and correct copies of any brokerage account statements, supposedly somehow going to the threat of reputational harm as a result of the filing down in Houston. He asked for any communication you received from or sent to the SEC as somehow going to the threat of reputational harm arising from the lawsuit down in Houston. Request for admission, these are on page 26 of our motion. Admit that you own 10% or more of WPD, which is an entity that is a non-party and has absolutely nothing to do with anything in this case. Admit that you are considered an insider at WPD according to SEC guidelines. Again, that's supposedly reasonably calculated to lead to the discovery of admissible evidence as to whether there is a threat of reputational harm arising from Mr. Kasab's Houston lawsuit. The interrogatories are the same. Provide contact information for any person or entity to whom you introduced to and who purchased shares of CNS, which is another non-party to this case that has absolutely nothing to do with the issues in the case or whether there is a threat of reputational harm arising from Mr. Kasab's lawsuit. Now, typically, Your Honor, when faced with discovery requests like this, I would just assert my objections and put the burden on Mr. Kasab to come get a court order finding that the discovery requests were proper. The reason that I'm in here on a preemptive motion for protective order is not because of these requests so much as it is for the two threatened depositions that he wants to take. He's indicated that he wants to depose two of Mr. Casey's business associates, and he wants to ask them about all sorts of reputational issues that he thinks goes to somehow this threat of reputational harm arising from the lawsuit he filed. None of that has anything to do with anything, Your Honor. The problem we're in right now is the same problem we were in that created this lawsuit in the first place. We've got Skandari using the civil discovery process to try to harm Casey's business. That's exactly what he was doing with all of those gratuitous statements he made in that lawsuit. This lawsuit is asking the court to stop him from making those gratuitous statements in other lawsuits. This motion for protective order is asking the court to make him stop trying to harm Casey's business through the civil discovery process. So we're asking the court to, again, make him stop, either through quashing this discovery or through granting the summary judgment and joining future breaches of the settlement agreement. Both will do the same thing. So I take either one of those from the court, and that's all I've got.
Response.
Yeah, Your Honor. Mr. Casey told this court in his petition that unless Mirskandari is enjoined, he will suffer irreparable harm in the form of, among other things, reputational loss of business opportunities. He also told this court in his summary judgment motion, a summary judgment was proper because irreparable harm exists in the form of reputational harm resulting from Mirskandari's disparaging statements. Your Honor, Mirskandari is entitled to discovery on those issues. If Casey can't come to this court and ask for an injunction and allege that he suffered a reputational harm and not allow Mirskandari to conduct discovery with regard to that. Now, he's filed a motion for protective order, and the rule requires him to come in and demonstrate a specific injury with evidence. And with regard to the depositions of Dr. Priab and Walter Kim, those are two business associates that Mr. Casey does business with. He requests the court to enter protective orders stating that the depositions are purely for harassment, but that's not any evidence to support a motion for protective order. That's just a conclusory statement. And the Dallas Court of Appeals is very clear that a party may not simply make a conclusory allegation that the requested discovery is unduly burdensome or unnecessarily harassing. And that's exactly what Casey has done. He argues that the depositions are being sought to harass. That's just factually incorrect. He says he'll suffer irreparable harm in the form of, among other things, reputational loss, and we get to do discovery on that. Casey, his only evidence with regard to the depositions is his testimony that to the best of his knowledge, neither Dr. Priab or Mr. Klimt read the petition. But the best of his knowledge is not evidence to support a fact. The law is very clear on that. And the law, if Casey does not know if Dr. Priab or Mr. Klimt have actually read the petition, that's just speculation, and it's not evidence to support a wholesale request for denial of the discovery. Casey also testifies that if the court allows these two to be deposed, it'll injure his business relationships with them. But again, that's a conclusory statement. It cannot support a wholesale protective order over those depositions. Counsel or Mr. Casey doesn't know what questions we're going to ask. He's admitted that they're business associates. We get to determine whether or not Mr. Casey's reputation was actually harmed before and after the Harris County petition was filed. It's relevant to this case. And Your Honor, so is the written discovery that we've served. It's completely improper for a party to come in and say he gets wholesale protection from all written discovery requests because he's got a summary judgment pending or based on a claim that they're harassing or burdensome. Those are objections that he has to assert to each individual request. And then, like counsel said, we can come here at a later time and I can seek removal of the objections and we can determine which specific ones should be answered. But for Casey to come in here and ask for a protective order is completely improper. Your Honor, the discovery, some of the admissions, since counsel went over some of the requests, I'll go over others because there was a lot of written discovery, but we asked admissions concerning whether Casey suffered any irreparable reputational harm as a result of the Harris County petition. That's requests for admissions 1 and 2, 18 and 31. We asked for admissions concerning Casey's current reputation to demonstrate that it remains the same. Those are requests for admissions 11 and 12, 19 through 22, 48, 61, 63 through 68. We asked for admissions concerning whether Mirskandari was within his rights to file the Harris County petition and whether the filing was a breach of the settlement agreement. Those are requests for admissions number 29 and 62. We asked for production seeking documents related to Casey's business relationships, which will demonstrate if those relationships are ongoing and if Casey has in fact been damaged or suffered any irreparable harm by the filing of the Harris County petition. And those are requests for production numbers 1 through 3, 14 through 16, 20 through 26. Your Honor, I could go on, but there's a summary of all those requests on page number 9 to our response. It continues through page 10. And if the court is to look at those individual requests, it'll see that they go directly to the issues and allegations being made by Casey in this case. And, you know, I don't think the court can do that in 10 minutes. I don't think I can go through them all in 10 minutes, which is why I think it's improper just to seek wholesale protection from all this discovery. I understand that the court has a summary judgment motion pending, but as of now, you know, there's been no ruling on it. We're entitled to proceed forward with discovery, and you know, we can take.
So let me make sure I kind of understand where we are. So we have a discovery that's been sent. He's objected to all of it. You haven't compelled on it, but there's these 2 depositions that might be scheduled. Is that the situation, or they have been scheduled?
You're somewhat correct, Your Honor. Rather than respond to the discovery, he just filed the motion for protection.
Oh, he never objected to anything.
No. I've received no responses to any of the written discovery. Instead, he filed this motion for protection, and he's asking for the court in his order to say that I don't get any written discovery at all.
So, you know, I think that's too broad. You know, I feel that a lot of the discovery that he talked about involving reputational, I mean, the 2 depositions you're requesting, I think would sound way too broad and not relevant. But that's not something I can rule on because, as I understand it, you haven't even noticed those, right?
That's correct, Your Honor. I sent an email to counsel asking him for his availability and with proposed notices that I intended to send out. And then that's when he filed the motion for protection.
I mean, and this isn't a ruling, but I cannot imagine a situation where I would not quash those, and I would probably consider sanctions. Those seem way overbroad given what this case is. Most of the discovery that you guys mentioned sounded overly broad, but some of the things that you suggested, like there was something about filing of the filing of the lawsuit in Harris County. There's nothing wrong with filing the lawsuit itself. It was the issue really is what was contained in the lawsuits and kind of the gratuitous attacks that were made in the lawsuit. That's where there's a potential issue. And so I can see some limited discovery about that, though I don't really know why you need that. But if you know, it's not beyond the scope, at least, to define the issues. That look, we're not suing over the filing of the lawsuit, just what was contained in the lawsuit. And so, so I'm not sure how to really do this. We could go through, you know, I guess I could protect against any discovery that's intended to go into the issue of damages in this case on defamation. I don't know if that would be helpful, or we could go through them one by one. I don't believe that I can just blanketly say I'm going to protect against all of it, because some of it does sound like it's marginally appropriate. So how do y'all want to deal with this issue? Do you want to just, Mr. Hopkins, you want to just object to what you want to object to, or?
Yeah, Your Honor, thank you. I'm fine with that on the written discovery, and the objections, I haven't started them yet because they're not due. And again, my principal issue is with these depositions. I hear what the court has said on that. I think it's appropriate for a protective order to be entered to stop Iskandari from pursuing those depositions. If he contends that they're relevant, then he can come to the court and get a further order after he explains to the court why. I'm not saying he can't take any discovery. That's not what I'm doing. What I'm saying is he can't do this because this is harassing. So if the court enters some protection over those depositions, then hear what the court's saying on the written discovery. We can do those objections in due course with typical litigation practice.
So I'm sorry.
No, I'm sorry for cutting off the court.
That's okay. Go ahead.
Your Honor, he is asking that we're not allowed to do any discovery. I mean, you know, I've read to you interrogatories that even the court believes are marginally relevant, and he asked the court to wholesale prohibit me from doing that. And so that's exactly what Mr. Hopkins is asking the court to do. And I can't
With
explain.
Mr. Kassab, though, I don't know if it was clear, and I probably wasn't terribly clear on this. I've told him he needs to object to those, object to them, because I agree, some of it probably is, most of it probably is not appropriate. He needs to object. I'm not going to just do it a wholesale motion for protection on that. So you've won that point. I do think these two depositions, absent some further explanation of why they would possibly, I cannot imagine a situation where they would be relevant in this case. And I'll just tell you my impression here, based on what I've heard in court, is just that this is a fight that the parties seem to just want to continue to fight, and I don't really see what the value of it is. And but you know, I'm not going to force you guys to end this lawsuit. It just seems a little pointless, the whole thing. But you know, that doesn't, you know, that's just kind of an editorial comment by the court.
Yeah.
But that being said, I will protect against these two depositions. The written discovery you're going to need to object to.
And Your Honor, I can provide a little bit of further explanation with regard to the depositions. Maybe it'll sway the court, maybe it won't. But you know,
I would find it extremely unlikely it would. But go ahead.
All right. Well, then I don't need to in that case. You know, we think that
that is, guys, the interns. That is good lawyering by Mr. Kassab. Good job. Listen, you're listening to the court. That's a good.
And I don't disagree with you that this case is, quite frankly, silly. I think that Mr. Mariscandari did what he had a right to do. Mr. Casey came in here and started this lawsuit. And, you know, I think that both parties clearly dislike each other.
I want to make it clear that's not what I'm saying. I'm saying that I don't know why your client had to include those gratuitous statements in the Houston lawsuit. That was totally unnecessary. By the same token, I don't know why we have this lawsuit. The simplest thing to do would just be amend that lawsuit. You don't need these statements in there. Your client's obviously trying to provoke the other side. He is allowing himself to be provoked. I think both sides are wrong, or not wrong, or both sides are making a bad economic decision here. So I don't want to make it sound like I think that your client is free from any type of blame. This could be easily solved by just fixing what's going on in the Houston case, instead of just generating all these attorney's fees and unnecessary waste of court resources. But so I don't want anything that I've said to be I think what should happen is that, but if they're not willing to do that, you've just provoked them, and now we're going through all this litigation that just is pointless, in my opinion. But
Your Honor, I asked for an amendment of that lawsuit to remove references to Casey before I filed this lawsuit.
and
The
Mr.
answer was
Hopkins,
no.
I agree, but now I mean, it's like, is it that big a deal? I mean, it's kind of like, I feel like you guys are fighting over, I'm trying to think of a good analogy, but you know, you're having World War II over gets the last piece of popcorn in the, you know, bag of popcorn. I mean, it's like, why are we fighting so much over there's already all these statements out there about this dispute. There's no way that you can put the genie back in the bottle. But that being said, I don't think he provoked, he kind of threw the first punch, and now your side has totally overreacted. That's my thoughts. But for the issue here today, depositions, the motion of protection are granted. For the written discovery, it's denied. You need to object. So get me an order on that, Mr. Hopkins. Get it to me by the end of the day. Ron, to try to print that out for me, or at least forward it to me. I'd like to get that signed I'm going to be in the office tomorrow, so I'd like to get that signed tomorrow. And anything else today, guys?
No, Your Honor.
No,
Appreciate the court's
Your
time.
Honor. Thank you.
All right, guys, you have a good day.
You too.
All right, bye-bye. Miss, I don't know, it's Mr. and Mrs. Cersei, are you here?
Yes, Your Honor.
What are you here for?
I'm here for an 11 o'clock summary judgment hearing.
Okay. And Mr. Joseph, what are you here for? Or Miss Joseph? You're muted, ma'am, or sir.
Can you hear me now, Your
I
Honor?
can.
I'm here on a second motion to compel, Your Honor.
Sorry, say that again.
I'm here on defendant's second motion to compel.
Okay. Let me pull up your case. Is that on Aldridge?
Yes, Your Honor.
Okay, is the other side here on that?
I don't see them, Your Honor, on screen, and they filed no response to the motion that I received.
Okay. Let's go ahead and go on the record on the motion to compel. Give me a second.
No, I'm ready to proceed.
Yeah, I'm sorry. Audrey, are we on YouTube still?
Yes, we are.
Okay. Let's go on the record on cause number DC 1917233, Aldridge versus Johnson. Counsel, make your appearances.
Harvey Joseph on behalf of defendants, Your Honor.
Okay. And
Or I'm sorry, defendant Johnson, Your Honor.
this case,
Okay.
as I understand,
Clement.
I'm sorry, say that again. Who do you represent?
I'm sorry. We represent both defendants, Your Honor. Johnson and Clemens.
You're kind of cutting in and out, so just be aware of that. All right, let's go ahead and make your argument. There was no response filed to this motion.
Yes, we filed a first motion to compel, which turned out to be an agreed motion. And you entered an order granting that motion on April the 10th of this year. And it required the plaintiff to respond to our discovery within 14 days of the order. They did not. They filed some responses, but some they did not file properly. I sent the plaintiff's counsel an email on June the 30th that is attached to our motion as an exhibit, pointing out the deficiencies in the responses and requesting that he cure those deficiencies by July 17th. He contacted me and asked if he could have an extension till July 20th to do that. I granted that extension, but as of now, that still has not been done, and that necessitated our second motion to compel.
I don't see that you filed an order for this. Did you file an order?
I thought we did, Your Honor, but if we have not, I can file that order this afternoon.
Can you go ahead and file the order? I will grant the motion, and can you go ahead and file the order as well as email it to my court coordinator?
Yes, Your Honor, I will.
And my court coordinator is Rhonda Pinson.
Yes, Your Honor, I will do both before 4 o'clock this afternoon.
Sounds great. Rhonda, make sure that goes on my stack. All right. Thank you so much, and you be safe, Mr. Joseph.
Thank you, Your Honor. May I be excused?
You may.
Thank you, Your Honor.
All right, Ms. Searcy, you're here on a summary judgment. I think it's not until 11. Is that correct?
Yes, Your Honor, that's correct.
Okay. And this is on Simmons First Auto versus Lopez.
Yes, Your Honor.
I don't see that a response was filed. Is that correct?
No, Your Honor, no response was filed.
Okay. Okay, we'll just wait for Ms. Lopez to see if she shows up because the hearing has not started yet. I'm going to go ahead and I need to shut off YouTube at this point.